seated. All right, we've got our third case, Brent Huber versus Allstate and McDonald, case number 242589. Counsel for appellant. And it's 5 minutes rebuttal.
Yes, Your Honor.
Okay. You may proceed.
Good morning. May it please the court. Stephanie Marchman with the law firm Gray Robinson on behalf of the plaintiff appellant Brent M. Huber, Inc. I also have with me my colleague Julie Zulte and client representative Linda Huber. Your Honors, this litigation has been pending over 5 years, with the complaint being amended multiple times during the course of the litigation to address the misconduct of the defendants that occurred after the initial complaint was filed in March of 2020. I've represented Huber throughout the course of this litigation and will do my best to succinctly address the salient facts contained in Huber's proffer. Evidence which, viewed in the light most favorable of Huber, supports a reasonable basis for the recovery of punitive damages against Allstate and Kevin McDonald. On Huber's pre-existing tortious interference claims against these defendants.
Before we get started with that, do we even have jurisdiction, that what was argued by the appellee, to even consider this? There was a motion for leave for punitive damages, correct? And then that was denied, and then you never appealed that, and now we have a second motion up on appeal. What is different between the first motion and the second motion?
Yes, Your Honor.
That would allow us to have jurisdiction.
Yes, Your Honor. The renewed motion up before the court on appeal does contain additional evidence in the proffer. The parties were in litigation over the discovery disputes. Allstate.
Did the issues that you were arguing change?
The evidence did change, Your Honor.
The evidence, but did the actual arguments that you were making, did they change?
Yeah. Well, we, in both instances, claimed punitive damages were warranted and the evidence supported punitive damages, but we did have additional evidence to proffer to the court to support our claim for punitive damages. So that evidence included the deposition of Karen Sullivan, who stated in her deposition that she was the decision maker to terminate Huber. Before, when we had the initial punitive damages motion, we had no testimony of any decision maker, and at that point, all of the Allstate witnesses said they didn't know why Huber was terminated. They didn't know who made that decision.
Are you saying that after the first motion was denied and the order was entered, that there was other evidence that came forward, and that is this new evidence that you're relying on to assert your punitive damage claim that you think the trial judge wrongfully denied last September? Is that what happened?
Yes, Your Honor. We're also relying on the prior proffer as well. We're relying on the whole course of misconduct that occurred from the very outset of the purchase of the business.
I think some of the theme is you can't just keep filing motions for leave to amend for punitive damages, and hopefully, the fifth time you're successful, or the fifth time you want to appeal. I mean, I think that's the point of what Judge Boatwright's saying is, okay, you had a hearing, you lost, you didn't appeal. Now, there's more stuff since that order that's come in that says, now that we have uncovered this is the basis for the punitive damage claim that can be asserted that you believe the trial judge recently improperly denied. Is that the lay of the land?
Yes, Your Honor. And Allstate filed a motion for a protective order with respect to Karen Sullivan, stating that she had, with an affidavit saying she had no unique personal knowledge of the situation. And we litigated that issue, and ultimately she did sit for a deposition claiming to be the decision maker, and I had the ability to examine her as to the decision, the proffered reason for terminating Huber, which was to allow McDonald to service customers and to get to terminate Huber because he sought an injunction. I examined her. I asked her, how is it that McDonald was able to service customers if that was your reason for the termination? She had no answer for that. In fact, he couldn't service customers because he was still under an injunction. What investigation did she do? Did she read the asset purchase agreement? Did she read the injunction? She had no answers to any of those questions. And again, all of that evidence tends to show, in Huber's view, that the real reason that Huber was terminated was because of Allstate's malice towards him. And
Why do
towards
they
his
have malice
company.
towards him?
I'm sorry, Your Honor?
Why do they have malice towards him? Isn't he one of their agents?
Because he didn't do what they demanded. They demanded that he dissolve the injunction. First, they intervened in the litigation, and when the court denied the ability, Allstate's motion to dissolve the injunction, they had a private meeting with Mr. Huber and demanded that he dissolve the injunction, modify the injunction on his own, also modify the asset purchase agreement, modifying the restricted covenants, all without consideration. And they gave him a threat. If you don't do this, we will terminate you. He didn't follow through with that threat. And they followed through with that threat and terminated
But
him.
the agreement allowed them to do that without cause. So, I mean, doesn't that make a difference?
In our view, it doesn't under the law because you can't employ improper means. You can't, I liken it to
Without cause
the,
doesn't always mean without cause?
well, I liken it to the employment context. If you're able in Florida to terminate an employee for any reason, no reason at all, but you can't do it for an illegal reason. In this case, Allstate employed improper means in the exercise of that right, which is tortious interference. And the court,
Well,
the
is there
trial
a claim
court,
for tortious interference? I mean, there's a claim for tortious interference. Why do you need punitive damages, though?
because of the party's conduct and the evidence in which the outrageous manner and in which they Allstate acted, in addition to actually terminating Huber to interfere with his agreement with McDonald, they continued on a bad course of conduct, which includes following the termination, Huber had the ability to sell the economic interest that he had in the agencies that he purchased for over $3 million within a 90-day window. He identified a buyer, Michael Carroll, who was an existing Allstate agent in Ocala. Again, Allstate interfered with that ability for Huber to sell that economic interest. And the evidence of that
Counsel,
is...
there was some policy in place that changed close in time to all that. Was the policy in effect at the time the sale was proposed to Carroll that did not permit the mergers, or had it already changed?
The policy was in effect, the policy that we got actually 1 month before we filed the renewed motion. And Allstate's position is the policy does not allow mergers. The policy that we actually received shortly before we filed the renewed motion does allow the mergers. Allstate didn't follow its own policy, which is again evidence of malice towards Huber. That the real reason that they didn't allow this merger to occur was to retaliate against Huber. That's our view of the evidence. Your Honors, in our view, the trial court erred by taking a look at this evidence and weighing the evidence and taking Allstate's view and McDonald's view of the evidence as opposed to Huber's view. For example, on the policy issue.
How did Judge Sanders do that? What did he do in his order in your view?
In the order, the court specifically said there's a genuine disagreement between Allstate and plaintiff regarding whether that policy applied in this situation.
Isn't there?
There is, but Huber's view of that evidence and the plain reading of the policy allows for a merger. And our view of the evidence is that Allstate didn't follow its own policy to harm Huber. For not complying with its initial instructions to dissolve the injunction and to help McDonald do what he was not permitted to do under the non-compete agreement and the injunction. In addition, the trial court also incorporated in its prior ruling, and the trial court found that the deposition testimony relied upon by the plaintiff suggests general confusion on the part of Allstate how to best service customers after the temporary injunction issued by the court. Again, the court's weighing the evidence and the credibility of the witnesses. Our view of the evidence was there was no such confusion. This was a calculated decision by Allstate to terminate Huber, to retaliate against him because he didn't follow what they wanted, which was to dissolve the injunction. And they wanted to help McDonald to service customers. But again, at the end of the day, the decision harmed customers. The testimony from Allstate's own witnesses was that the decision that they made created a problem for the customers. The customers that Huber had no Ocala were left with no local agent. They referred the customers out to agents in Bella, Florida, Gainesville, Florida, outside the local area. Again,
Whether it was a good decision or bad decision doesn't really matter, does it?
what it shows is that the company, that Allstate didn't follow its own policies and made a decision based on its malice towards Huber. As opposed to, why else would it make such a decision? That's up for the jury to determine whether those decisions that didn't add up, didn't make any business sense, didn't follow their own policies, was really a calculated decision to retaliate and harm Huber. And that's up to the fact finder at this point, the jury. And that's all we're asking. We're asking for the opportunity to present this evidence to a jury and allow that jury to make that decision. In this case, the trial court, we believe, applied a heightened standard, and accordingly that the decision ought to be reversed. I'll reserve the remainder of my time for your honors. Thank you.
Thank you.
Good morning, Your Honors, and may it please the court. My name is Eric Coleman. I'm here on behalf of Belly Allstate Insurance Company. And I'm splitting my time with co-counsel for the McDonald defendants. So I will be as brief as I can in 10 minutes.
I'll leave that up to y'all to tag out.
Yeah, understood, Your Honor. So as in hitting first on the issue of jurisdiction, we do believe that the court does not have jurisdiction to hear this appeal. The initial motion was filed in November of 2023.
Wasn't their proffer different?
No, Your Honor. And when I say no, I mean that the evidence was not new. So
they already had the deposition of Allstate beforehand?
They had deposition of other Allstate witnesses that testified to the exact same issues and gave the exact same testimony as Ms. Sullivan. And so while Ms. Sullivan was a new deponent, a new deposition transcript, the information she gave was not new, and it was consistent, as Judge Sanders found in the trial court, was consistent not only with the other witnesses, but also with the documented evidence that was provided to the plaintiff prior to her filing the first motion. And so I don't believe that the law allows.
What about, was the merger policy documentation, was that something new?
The merger policy was not new as well. They were aware of the policy that was in place. The documentation that was provided after the fact was consistent with the testimony and knowledge of the policy beforehand. So none of the information that was contained within the new proffer was in fact new evidence. It was new documents, it was new testimony, but it was not new in the sense that it gave some different understanding of the facts or policies that were not already known.
So basically, as I understand your brief and what you're saying now, it was more of exactly the same that you already had.
That is correct, Your Honor. It was more of the same. That is exactly what Judge Sanders found in relation to both issues. And he stated, this is not new with regard to Ms. Sanders, and this is not new with regard to the policy on the merger.
So were the other Allstate employees who were deposed prior to the first motion being heard, were they decision makers as well? I know your opposing counsel says Ms. Sullivan was a decision maker, sounding like she was higher up on the Allstate food chain here and made the decision that they think had balance.
She was higher up on the food chain, but she relied on the people that did the underlying work. And what happens is that there's a termination request form that goes through HR. That termination request form lays out all of the information regarding the decision. And in this case, there were these ongoing issues. Ultimately, Allstate terminated without cause instead of with cause, but it's still the termination request form still laid out everything that was ongoing. And so what the plaintiff was aware of was all of the issues and reasoning going into the decision to terminate Mr. Huber. What the plaintiff received when she deposed Ms. Sullivan was the exact same basis. So there was nothing new that Ms. Sullivan provided, even though she was the one that signed the document. Ultimately, she signed it for the reasons that were already known to the other side. In turning now to the more of the substance, starting with the policy on mergers. All state follow its policies at all times.
So let me ask you, if it's true that Allstate actually did retaliate against Huber by terminating the agency agreements, would that be enough to plead punitive damages in this case? Just because you have a without cause terminated as part of those agency agreements to be able to terminate?
I'm not sure if I understand your hypothetical. Are you asking whether or not terminating?
Allstate actually retaliated. Their decision was they were upset at Huber for not terminating or not modifying this injunction. Is that enough to plead punitive damages in relation to the fact that you have this, that you can terminate these agency agreements without cause?
I would say, Your Honor, that it is not enough to plead punitive damages because under the law, if you have an agreement that allows you to terminate without cause, your motive is irrelevant. The law on towards interference is improper means, not improper motive, and there is a difference there. Improper means just means you have to use a justified method in terminating. Here, we have a contract that says we can terminate. So that act of enforcing our contractual rights is not an improper means in regards to interfering with the contract.
Malice or outrageous conduct doesn't matter.
It does not matter when it comes to terminating under the contract where there is a outright right to terminate without cause.
So they could say, we don't like this fellow anymore. He's been a thorn in our side. We're just gonna, we don't have to have a reason. We're just gonna say, hey,
Yes.
all done with you, Mr. Huber, for, thank you for your service, but all done. Have a nice day. And we're doing it because we don't like you anymore.
Yes, Your Honor.
That would not elevate it to punitive damage if there was.
Under my understanding of Florida law, including the 5th BCA's case, the Essex case, I can pull the citation, the motive is irrelevant when it comes to terminating where you have an absolute right under contract to do so without cause. On the issue of whether or not the judge applied the correct standard, everything within the judge's order is he cites to the correct law, and he does not weigh the evidence. The judge is considered the gatekeeper when it comes to punitive damages because the statute is designed to preclude or prevent punitive damages being asserted against a defendant until there is substantial evidence that gives a reasonable basis for recovery of such damages. And so the trial court judge is required to review the evidence. It's required to review the evidence and consider things in the light most favorable to the plaintiff, but it's not required to accept the plaintiff's statements as to what that evidence means. And so in this case, the Judge Sanders, and I ask you to do the same, reviewed the evidence and made a determination that while there may be evidence to support intentional torts interference going to a jury, there's not enough evidence to rise to the level necessary to establish a basis for punitive damages. And that is
all intentional torts don't equate to punitive damage.
That is correct, Your Honor. The basis for an intentional tort is not ipso facto a basis for punitive damages. In the case law cited in our briefing on that issue, and that is what we have here, where there was a summary judgment motion where the court said, "Oh, there's enough there to go to a jury." That in and of itself is not enough to say that you also are entitled to punitive damages on this tortious interference claim. Lastly, I'll just touch on the other issues that were raised in our brief. We also believe that at this point in the case, the plaintiff has abused the privilege of amending. This is the sixth attempt to amend these pleadings. And at this point, we do believe, and we are below that, the court should just deny on that basis alone. And so that's another basis separate and apart from the merits of whether or not punitive damages should be allowed.
There was one prior request to amend for punitive damages, right?
Yes, there was one of the prior requests.
I understand what Judge Sanders wrote in his order, but I mean, if egregious facts came out between round one and round two, I mean, the fact that it's number 5 or 6 pleading, it's only the second one directed at punitive. That wouldn't seem to be an abuse of discretion.
Understood, Your Honor. And so our argument is that there were no egregious facts that came out.
Well, yeah, that's apparently what Judge Sanders kind of thought, is saying you're just rerunning the same thing before, and there's no new evidence here. The same theme, it's just a different witness, I guess, different decision maker he was referring to in his order, I guess.
That is correct, Your Honor. It's just a different decision maker, yes. And if there are no further questions, I will cede my time over to co-counsel. Thank you.
It's gonna be three in here or no? You just do-
Just me. Good morning, and may it please the court. My name is Robert Bassel with the law firm of Gooding and Bassel, PLLC in Ocala, and represent the appellee, Kevin McDonald, along with my co-counsel, Mr. Gordon Glover of Ocala. I want to start by somehow just, I won't try to distill 5 years of litigation into 7.5 minutes, but I want to take off on the first question asked by Judge Boatwright, and that is, and the new evidence against Kevin McDonald. He is the principal of McDonald and Company, which is also a defendant. And I want to read to you, now, please understand, Mr. McDonald was not the subject of the first motion to amend to plead punitive damages. That was between the plaintiff, Huber, and Allstate Insurance Company. Of course, Mr. McDonald, an agent in Ocala. I'm going to read to you just briefly a blurb from the hearing on the second motion to amend, which did include Mr. McDonald. In August of this is Ms. Marchman. In August of 2023, the McDonald Agency, at the direction of Mr. McDonald, improperly accelerated the note and brought claims against plaintiff and Mr. Huber individually for immediate payment of the balance, the note. Notably, Mr. Huber died a few days later after this, after he received the demand. The court. So is the only new evidence you're offering as to McDonald the acceleration of the note? Ms. Marchman. Yes, Your Honor. You'll find in the appendix of the appellate's brief a promissory note at page 1104. And what happened is Mr. Huber paid the note over time, a $600,000 note as part of the purchase price. When his agency was terminated, there were payments made by the lender directly to Mr. McDonald because he was collateralized with the financing, but it wasn't enough to pay the balance. So therefore, even though there was a prepayment, there was a month came shortly before trial where the monthly payment was not made.
How much was still owed on the note?
$245,000, I believe.
Okay.
And Judge Lambert, that's one of the points, if I'd like to develop, given more time, when we get to the
Page
issue.
46, so.
Okay, when we get to the issues of, what's motive, intent, egregiousness, and bad behavior, which would justify the imposition of punitive damages, Kevin McDonald had 800,000 reasons for Huber not to be terminated. A $600,000 note and a $200,000 note, and he was the landlord of Mr. Huber, one of Mr. Huber's Ocala locations. That can't be lost in the analysis of whether Mr. McDonald acted egregiously and did all of the things that are now alleged or claimed, which should result in some reasonable inference that a jury could find conduct supportive of punitive damages. It's just not there. Now, you read in the briefs, in the appellate's brief, several things that they claim, like he violated the no-compete, that he signed a contract which was contrary to his obligations to Allstate. Well, that's his contract with Allstate, not Mr. Huber's contract with Allstate that this tortious interference claim surrounds. And so I know it's a continuing battle for an appellate court to determine, especially now with all of the appeals regarding this particular subject. I know the Supreme Court's considering it now. And so the question always arises, what's the trial judge supposed to consider and not to consider? I think you lay it out in word. And Judge Sanders did that in this case. and reached the conclusion that as to Kevin McDonald, no one, the evidence wasn't there to lead or raise any reasonable inference that he acted in any manner that was egregious or that was otherwise supportive of the notion that punitive damages should be allowed to be pled. All of the things, and I hate to summarize all of these things, but I don't have the time to enumerate all of them that you find in the briefs, but entering the APA with a conflict, violating the non-compete, didn't comply with the injunction, and then he sought out Allstate to terminate Mr. Huber. Even if everything in the proffer is seen in the light most favorable to Huber, the proffer itself contradicts the notion that Kevin McDonald had anything to do with the process, the thought, or much less the actual termination of the Huber agency. He had every motive, intent to want, and the motive and desire for Mr. Huber to succeed. Yes, there were problems that arose after this transaction closed. Way too many, too granular for me to get into today. But all of these matters arise from the underlying contract claims made by the plaintiff, not any alleged tortious interference claim involving the contract between Huber and Allstate. Mr. McDonald had that intent, motive, desire that I've described beginning months before this transaction even closed, and it continued because he had a lot invested in it in itself. He benefited in no way whatsoever from Huber's termination. I would ask you to take a close, and I know you will, a close look at the record regarding the communications between Mr. McDonald and the folks at Allstate following the injunction. You're going to see in the proffer an email from Kevin McDonald to Allstate 1 month after the injunction's entered, wherein he transfers and sends to Allstate a list of policies that says, here, take these. Our interpretation, then and now, is that the court's injunction was overbroad. However, the overbreadth of it, what it resulted in was, it's our position, that certain policies were excluded assets. The court's injunction could be read to say you can't service those clients, or you can't receive compensation from those clients. So what does Mr. McDonald do instead of not complying with the injunction? And again, I'm getting at what is shown in the actual proffer. He gave up a substantial amount of business so that he wouldn't be held in contempt of court until this lawsuit works its way through the process. He doesn't own those policies. Allstate does. He can't control their transfers. Allstate does. So he did everything in his power within 1 month of this injunction, and the sought out part, sought their help. Sure, he sought their help to find out how to service his own customers or have his customers serviced under these circumstances. I'll close with there also was numerous text communications. And the very last one of 30 pages of text says, please, I need to hear from you. I'm getting nothing but silence, meaning Allstate's not telling him what to do. Is that a reasonable inference? That he was asking them to terminate? It's a reasonable inference that he was trying to do what he could do to take care of his customers and to comply with the injunction. None of which raises the inference by which this court could find that that the complaint should be amended to plead punitive damages against Kevin McDonald. Thank you.
Your Honors, Mr. Batzel makes a compelling argument for Mr. McDonald, but again, that's an argument, that's his view of the evidence, and an argument that he should present to the jury. Mr. McDonald and Allstate had a lawful reaching their intended or purported result. The concern of Allstate, the stated concern of Allstate, was for customers to be serviced. Allstate and Mr. McDonald and Mr. Huber all agreed that those customers that posed a problem for Mr. McDonald in terms of the injunction could have been transferred to Huber for service. Mr. McDonald never transferred those customers. Allstate never transferred those customers. And indeed, the meeting with Mr. Huber and Allstate, we believe that the intent of that meeting was to transfer the customers so that Mr. McDonald could comply with the injunction. Rather than that occurring, rather than taking lawful means, Allstate decided to retaliate against Mr. Huber and his company and totally destroy his business. The evidence, I want to address further the new evidence on the renewed motion that I failed to address previously. Michael Carroll's deposition was also added to the proffer. He was the agent from Ocala. We also, the merger policy, again, Allstate's position all along had been the merger policy did not allow the merger to occur. The policy that was actually produced to us 1 month before the renewed motion says that it could occur. That's the black and white language of the policy. The acceleration occurred after after the first motion. I also didn't mention the federal lawsuit. That was something that we obtained in discovery after we filed a motion to compel. It turned out Allstate actually prepared a federal lawsuit at the same time that they decided to terminate the business against Mr. Huber in his individual capacity. And they prepared that lawsuit based on allegations, factual allegations that there's no support for it, either factually or legally. No, Your Honor, they did not file it, but they did prepare the lawsuit. In our view of that evidence is they prepared it because they were going to put whatever pressure they could put on Mr. Huber in order to completely destroy him and his business. With respect to Mr. Pullman's argument that motive doesn't matter, they could make the decision for any reason at all. Allstate presented that argument to the trial court at the summary judgment stage, and that was denied. Summary judgment was denied on the tortious interference claim, and the court said that that was up to the jury to decide, and motive did matter, and the means mattered. Happy to answer any.
About what Mr. Batzel was arguing, subsequent to the denial of the first motion for sort of punitive damage claim, was what other evidence occurred vis-a-vis Mr. McDonald himself? That Mr. Batzel said he sent a demand letter because your client was allegedly in default on a note. Is there anything else in the record that Mr. McDonald did between first motion and the second motion that justifies?
Yeah. Your Honor, as Mr. Batzel mentioned, Mr. McDonald wasn't the subject of the first motion. Right. So we elected with the second motion to add Mr. McDonald. The new evidence against Mr. McDonald after the first motion that he wasn't subject to was the acceleration. Our view of that evidence was Mr. Huber was not behind on that note. There was no evidence that he was behind on that note. He didn't even know what the termination payments were in terms of what Mr. McDonald was receiving. It's our view of the evidence that acceleration of the note a month before trial was intended to put financial pressure on Huber. And again, demonstrates a course of misconduct and malice towards Huber. For all those reasons, we'd ask that.
So, if Mr. Huber was in default, could that then somehow be a basis for a punitive damage claim by sending that notice if in fact he was in default?
If he was in default.
What Mr. Batzel's saying, the only thing that we did was we sent out a letter saying, you're behind on your note, we're accelerating you. It's apparently consistent with the terms of the note. if he in fact was in default, I mean, how could that be a basis for punitive damage against Mr. McDonald? I mean, all state aside, but.
Yeah,
Mr. McDonald.
our view is that he wasn't in default, and the purpose of the acceleration was to put financial pressure on Huber and to further retaliate against Huber, and it showed the malice and outrageousness of McDonald's conduct, that it wasn't a lawful acceleration in terms of what they did here. Again, looking at the timing, looking at the facts of what happened, the evidence and the proffer shows that
Is there proffer from your side that shows he was not in default?
the evidence shows that in January of 2023, Mr. Huber sent correspondence to Mr. McDonald stating that he was directing the termination payments towards Mr. McDonald, which amounted to essentially a prepayment of 29 monthly payments. I think the payments were something around $5,000 a month.
Right.
Mr. Huber had no knowledge as to when those payments would stop, how they would be distributed to Mr. McDonald, had no knowledge that he missed a monthly payment.
But I guess what I'm trying to get to is, all right, so Mr. Huber did that, and then at some point, Mr. McDonald down the road says, okay, I have those, because apparently it went from 600 to 245 what was owed. I have those, but I haven't got the recent payment that's due this month, so I'm sending you this acceleration document, which I guess is permissible, right? For putting malice aside, just a pure, you either paid or you didn't pay,
Yeah.
I'm sending you this notice. And then my question is, if that's the basis why Mr. McDonald may be punitively liable here, was there evidence in response from the Huber side saying, well, wait a minute, this is more evidence of malice because we were up to date, we're current. See Judge Sanders, that we were current. This is evidence of malice, he's just making this up.
Yeah, Huber didn't know that there was a missed payment.
Well,
And
but that's not really the issue. Was there a missed payment or not?
we don't know.
If there was, but I think maybe that's what Judge Lambert's asking. If indeed there was a missed payment, in other words, the termination money had run out, why wouldn't McDonald be entitled to accelerate if the March payment wasn't made under the terms of the promissory note? He's entitled to accelerate, and your answer to us is you don't know whether there was a missed payment or not.
Our view of the evidence was there was no, Huber's view was there was no missed payment, that there was.
The question we keep asking is, what in the proffer shows he was not behind? You say he didn't know he was behind.
Well,
That's different than he was not behind, if you understand.
the Huber, again, applied the termination payments for 29 monthly payments. That's what he believed McDonald agreed to, based on the letter that
How
he
were
sent
we in when the note was accelerated?
August of 2023.
Of the 29 months, man. You said there was 20 months, it should have covered 29 months?
8 months.
8 months.
Because it started in January of 2023.
And I guess then the follow-up, what we're all trying to say is, so when Mr. Huber gets that, saying, hey, wait a minute, we're 8 months into this, you've got 29 months ahead of time, you are not in default. Here's our response to the demand letter, McDonald. We don't know what you're talking about. Show us how this could possibly be there. And I'm gleaning from your discussions with us today that there's no record evidence or proffered evidence from your side in response to the demand letter. Am I accurate with that?
There is no response, Your Honor.
Okay.
Mr. Huber died by suicide that week.
All right.
Your Honor, we respectfully ask the court to reverse the trial court's decision and allow Huber to plead punitive damages to present the charge.
Thank you very much. We'll be in recess. All right.